So let me just, while they sit down, yes, sit there, and let me just, please everyone, it's not coffee time. We'll start with coffee in a bit. So part of the discussion we were having with the panel earlier brought out, of course, the role of the courts. And this is something that we are aware of, that whatever the agencies decide to do, in the end, it is the courts that will have the final words as to whether a decision or a policy is going to be sticking. I heard you, Marc, when you were at the Lisbon conference talking about the winds of change. You were saying, as a judge, of course, you are aware that there is shift, as we described. And the question is, how do you think judges and the courts are essentially viewing, perceiving, internalizing this shift? There's an expression, drums beating from the hills. There is drums beating down. Is this kind of being heard? How do you feel it?
Judges listen. That's their job. So now, do they listen to economic theory? Do they listen to conferences? Do they listen to policy changes? I don't know. But I will give a long answer to your relatively short question, because it's a complex one. As a rule, the Commission sets the policy, or the national authorities set the policy, and the judges control. That's also a difference with the United States system, which Rebecca mentioned. We check the legality of actions. We don't have our own agenda. So I think that's important to bear in mind. Of course, when we do that, we have to interpret the law. And we always fall back on the treaties. But there's, of course, secondary legislation. And that's a matter of the Council and the Parliament. So judges operate in a frame. Of course, they interact with society, but they are passive. And they also act in a procedural straitjacket. For example, the General Court, even if you have an opinion on a certain case, if the arguments don't correspond to your opinion, you cannot make your opinion prevail. It's the party that must prevail that brings the right arguments, even if your conviction is somewhere else. And that's a difference between legality control and the adversarial system, which you have in the United States. That holds in particular true for the General Court, which is very much embedded in a procedural framework, less so for the Court of Justice. And you will see that in the case law, because the Court of Justice interacts with national courts via the preliminary reference procedure. And you see often changes coming rapidly or more less slowly to the court via the preliminary reference procedure than via the legality control procedure. Now, this being said, changes must also be slow for judges. And that may be an element of discussion, because we are supposed to maintain the rule of law and legal certainty. You cannot change the rules overnight. It's not because suddenly there is a new idea or something that we can or must change things. People have built houses on certain prospects, for example, for the tax reductions for mortgage loans, or you build a certain transaction as companies relying on existing case law. So it's difficult to change the law. Even so, and that's not the answer you wanted to hear, and that's not what my Lisbon speech was about, so I will recycle my Lisbon speech, because we live in a circular economy, do we? And the question is, yes, how far do I go back? How far can I go back? In fact, well, I think it was Tommaso saying that, yes, there are many young people here, so I could go back 40 years, because I started to work in competition law 40 years ago. So I will use a spectrum of 40 years. I could have gone back having listened to the panel, 60 or 90 years, because you could have invited, I think, Walter Eucken or Franz Böhm to this panel. I think they would have perfectly fitted in. But I will limit myself to 40 years. So I see three phases. The first phase is the market opening phase of it starts from the 80s to 2004. I think that's the culminating date. Then from 2004 until 2024, and then, of course, the question you want to know, what next? So the first phase of market opening, the period of Jacques Delors, the period of making the internal market work. It's important to bear that in mind, because you open up the market by having broad prohibitions. Everything is prohibited. And then you create a legal vacuum. What happens? Regulation. Harmonization rules. You have, for example, Cassis de Dijon, Dassonville, that type of case law created a need to regulate. Same thing with Article 85 at the time. It was a parallel to the free circulation rules. You would have a prohibition that would kick in relatively easily and basically prohibit any form of commercial restriction of commercial freedom. Hence, creating the need for exemptions. And if you have a look at the exemption policy of the 1980s or early 90s, it's often industrial policy, the restructuring of the chemical industry, the restructuring of the telecoms industry. So that was the period then. All very nice, but it created a problem. It created a deadlock before national courts, because the Commission has limited resources. We heard Olivier Gerson saying that. It's the same story of the 1980s. It was impossible to grant exemptions to everything, and that led to deadlocks or blockages before national courts. So the Court of Justice reacted to that. So courts listened and came to a more liberal interpretation of Article 101. In fact, 101 was applied in a more economic approach. I would even say, and I could defend that the Court of Justice was the entity that led to the more economic approach to deblock situations before national courts. Then comes Regulation 1/2003, and that's the major shift. That's a time changer, because that implied that you could apply Article 101, or that Article 101, paragraph 3 could be applied directly. And the idea was to have a more economic approach on Article 101, paragraph 1, so less cases under the prohibition, but also significantly less exemption decisions. Basically, since Regulation 1/2003, we haven't seen any exemption decisions. It's lettre morte. And national courts or national authorities can't apply that either under Article 5. And the idea was, okay, we have an economic approach. We only go for the things that are bad, which affect consumer welfare. So there is no need for us to be generous under Article 101, paragraph 3, because we have been very strict at the level of the prohibition. So that was a first tendency. So there's no policy, no exemption policy. We have seen a similar trend under Article 102. And there you see also that courts listen to what happens. First you have the guidance paper on the priorities. The courts react. First under Article 267, the preliminary reference procedure. If you a case like Post Denmark, for example, is a clear reaction to what the Commission said in its enforcement paper. And then ultimately Intel in 2017, which again leads to a change of the Commission's paper. So there is this interaction to which Olivier referred. So that's the second phase. Now the third phase, which starts in 2024, or which has already started, I would say. And there are two major problems. First, the one Andreas mentioned. There is an enforcement problem. It is obvious that the procedures we have are not fit to deal with these things. And we are perfectly aware of that internally. The problem is our rules of procedure have been designed in the 19th century, and they are not fit for those type of cases. You mentioned the Meta case, I can mention the Intel case. I think in the meantime the people are dead, which were in the dealing with the infringement. So and we miss the purpose, and we are perfectly aware of that as a court, and we do our best to deal with it by speeding up procedures. But it's also the conduct of the parties, because they use all the tools which are in the procedural toolbox. So that's problem number one. The second problem is that is this system complying or responding to societal needs? For example, when it comes to the environment. If there is no exemption policy, companies cannot cooperate when it comes to environmental standards or things which are good for the environment, because, it's not necessarily those who have suffered from the restrictive practice that will benefit from it. It could be third parties. Is that something which fits under Article 101, paragraph 3? And then, of course, the digital age. Procedures like Intel and the length of those proceedings are completely unfit for purpose. So those are the two problems we have to deal with. Now, I see three signs, and I will finish on that, which imply that there is a change in the system. First, as to the level of the prohibition under Article 101, paragraph 1, the idea was to have an effects-based approach, more economic analysis approach. But you see the courts becoming very reluctant. First with the object-effect discussion. You had carte bancaire, it should be effects. But carte bancaire has been taken over by Allianz Hungary, cases like Generics UK, or the Portuguese electricity case, or recently the football cases. Again, everything shifts from effects to the object box. Then Article 101, paragraph 3, the possibility to exempt. There is resistance at the level of national competition authorities in the field of environment. Is the Commission right, or are the national competition authorities right? And there again, if you read the football case of the 21st of December last year, there's a whole part on Article 101, paragraph 3, which is not as restrictive as what the Commission suggests, at least in my reading, which is a personal reading and doesn't bind any court whatsoever. So there are changes at the level of 101, paragraph 3. Then the DMA. It's a typical hard and fast rule system, comparable to the block exemptions we had in the 1980s. Everything is forbidden except if it's explicitly authorized. That's the type of system we are dealing with. It is basically the same as the system we had. All this to say that there are changes, things happen, they happen slowly, and they all happen under the Protocol 27, which lists down the objectives of competition policy. And it's so flexible that it can host everything ranging from consumer welfare to, say, controlling economic power. It's a system of undistorted competition. Thank you.
Thank you so much. I want to go straight to Marcus Smith, President of the UK CAT. We are fortunate that there was an opening in his diary, so he was able to join us. Marcus, the CAT has had to deal with some pretty frontier cases because the CMA in the UK has been a fairly progressive agency, so you've had to deal with a lot of digital cases, you personally and others. Where do you stand on this question of are the courts listening? We see in the US that there is perhaps some sign that the judges that were supposed to be quite reluctant to embrace some of the changes that the agencies are implementing are beginning to listen. Let's hear from you.
Well, Christina, thank you very much for the accommodation of my diary, and it's a pleasure and a privilege to be here. That being said, I think Marc and I both feel like a couple of Christians being thrown into the lion's den of policy. I want to start by saying that Marc has done a great job on defence, which I'm going to carry on, but I'll try and end my few minutes by giving the policy line a little bit of a bash on the nose, if I can. So over to defence first, and I'm going to try and add to, rather than repeat, what Marc has said, because what he said I agree with. One of the key things is differences in process, and Marc has already mentioned the constraints that courts operate under. One of the enormous advantages that the CAT has is that it hears evidence, and that is, I think, quite critical to what I'm going to say now. So it's usually said of judges that they should listen 90% of the time and interject for the remaining 10%. And that is a very good rule of thumb for witness actions where the court is receiving evidence. It's a far less good guide for hearings that turn on argument rather than on the taking of evidence. When it comes to argument, courts can, and I think should, be interventionist. Where there is an oral tradition with capable advocates that accompany it, it is actually a waste of resource for the court not to articulate what is troubling it and to get the parties' best answers. So the starting point to this really interesting question, it's a great question, is yes, the courts do listen. It is a critical attribute of a court's functionality. The reason the question is interesting is because of what it leaves unarticulated. The key question reframed is, to whom should the courts listen? That question underlies the distinction that I have drawn between evidence, to which a court must listen, and which it must weigh, and submission, to which a court ought to listen and seek to be persuaded by, but because, in particular in our adversarial system, also challenge and treat with a healthy scepticism. Because, in an adversarial system, each party argues its own cause. Put another way, when push comes to shove, whether it is evidence or submission, the court should ultimately listen to its judicial conscience. My judicial oath referred to doing right to all manner of people after the laws and usages of this realm, without fear or favour, affection or ill will. It's a bit Victorian, but it says it very well. The court should only listen to parties in the sense of doing what they advocate if it is consistent with this overriding obligation to the rule of law. And that is as true in the sphere of competition law as it is in any other region of law. So the immediate answer to the question posed, which seeks to press a link between policy and legal outcome, is actually a resounding no, even in the context of competition law. Law is law, policy is policy, and the two inhabit very different fields. Perhaps that is particularly so in the competition law context, because in the UK, as in the EU, the lead competition regulator is an administrative body that acts as judge, jury, and executioner. The CMA and the Commission investigate and decide and punish. The price they pay for that enormous power is close judicial regulation. And it is right that this price be exacted, for that is what the rule of law demands. And that is as true of administrative bodies as it is of courts. Never forget that the CAT is itself subject to the appeals to the Court of Appeal, and the Court of Appeal is itself, in the UK, policed by the Supreme Court. But even that rather bald answer is an oversimplification. Courts, it is trite, shouldn't venture into the realm of policy or discretion second-guessing in the case of the regulator. And the tribunal that I preside over has never sought to encroach upon the legitimate policy areas of the agencies it polices. And that can be made clear in three areas that I'll briefly touch on. First, in terms of procedure, what to investigate and how to do so. The regulator must steer their own course, subject to broad judicial oversight. In terms of penalty, why should a court superimpose their view on that of the regulator? I appreciate, of course, that the standard of review in the UK for penalty is on the merits, but there is a long line of authority, which I won't go into, holding that the CAT does not need to reinvent the wheel and does not have to second-guess a proper CMA-determined outcome. In terms of remedy, take, for example, price controls, where there will be many different ways of framing the control, provided the regulator's remedy lies within the range of reasonable outcomes, why should the court interfere? There is a wealth of case law in the UK saying that this is precisely the area where the court should take a step back. That is as much the case where the standard of review is on the merits as it is by way of judicial review. The on the merits judicial review distinction is one that rightly puzzles most of our colleagues abroad, and I'm not going to say more on what is a distracting topic in the UK. I don't think it's relevant for purposes of my talk today. The point that I'm making is that in these areas, the courts do listen, and they listen very carefully to the policy decisions of the regulator that they police. They listen in order to determine the proper limits for judicial intervention in this sort of case. Only when those limits permit intervention will the court's ability to intervene be triggered. Jurisdiction is both a hard-edged and a soft-edged constraint on judicial power. It works far better as a soft-edged, flexible constraint. Hard edges, if I may coin a phrase, make bad law. But these are policy areas which lie very far from the reorientation of antitrust that our previous panels have spoken of, and it's to that I want to turn as my last topic. To what extent ought a court to listen to such reorientation, to the extent it is occurring? And I heard very carefully the idea that, in fact, it's the same old, just under different clothes. Now, my answer is, again, a bald one, not at all. We shouldn't listen to policy. But, again, this apparent lack of nuance hides a great deal of complexity. Our competition law, UK, EU, US, turns on a recognition of the role of the market in a mixed economy. Other societies may differ profoundly, and there will be differences even amongst the states comprising these blocks. But the fact is there is a policy question, the role of the market, how it should operate, that lies at the heart of competition law and informs competition law as such. So the role of the market in a mixed economy implies, I think, two important legal classifications between different types of substantive law. And these classifications are ideological. But, like the rule of law, which is also ideological, they are inherent to our very society. A communist or a command economy would be structured very differently. So in terms of substantive law, I would differentiate between two classes. First, laws needed to make the market work. I bridle at the term free markets, because no market can truly be free of law or regulation. There will always be need for contract law, property law, a law of money, private international law, a law of persons. These laws, if misconceived, can operate as a bad constraint on the market to no public good. But properly conceived, they are facultative. They make markets work. My second area of law is substantive law that constrains the market. These are no less important in a mixed economy, stress the word mixed, and they represent an interesting and largely unexplored borderline for competition lawyers. Laws regarding minimum wage, discrimination, the environment, data protection, privacy, these have nothing to do with the proper operation of markets and are likely to have a distortive effect on how markets would operate absent such regulation. But that in no way undermines, it reinforces their essential purpose and validity. But properly conceived, they are constraints. They make markets work differently. And the meaning and application of these laws, both types, is profoundly a matter for the court. And policy should not play a role in determining their meaning and how they should apply. I'm not, of course, excluding purposive construction of statutes. That's an accepted and well understood rule of statutory interpretation. But it is one which, if one considers the books, which I'm not going to, is very far removed from policy in the sense that I'm using it. But law, as we understand it, forms an element in the norms or standards that regulate our conduct. Law is applied to fact, or facts are characterized by law. And this is where the role of the expert, to me, is critical. There's a critical synthesis between law and fact, and it is this that informs competition law's response and the court's response to developing economic understanding. What happens, at least in my court, is that the development of economic understanding on the part of the court goes hand in hand with the economic evidence received from expert economists. So competition litigation before the CAT, uniquely for the UK, resolves matters that affect third parties generally. That is not simply where the tribunal exercises its JR functions in public law, but generally across the board. Competition law is thus in contradistinction with most civil litigation, not simply concerned with bilateral fact. Relevant facts can be market-wide, and I include in fact economic fact that is no more an assessment of the aggregation of preferences of multitudes and a consideration of the implications of this. And too often, economists come before the court not knowing how the court will approach questions of economic fact, and therefore they have to articulate things from scratch. And that's both inefficient and unhelpful. Questions of economic fact will always be that, fact-dependent on many pieces of evidence, but we must articulate in our judgments how we see economic fact, how we approach it, and give the economists who appear before us a target to push back on. Take something like two-sided markets. We've articulated in our compare the market case how we think two markets operate. That was based upon very helpful economic evidence that we heard. Next time round, we'd like economists to say, well, you said this last time, we agree, or you're wrong, and here's why. And so our understanding of economic law, economic fact, will continue. And what we will end up with, I hope, is that ex post becomes the new ex ante. We decide our cases and we act as a guide for the future. I'm sorry I've overrun.
No, I would like to start by apologizing if you do feel like Christians in the lion's den, but it wasn't the intention, but it is very important for this conference to have statements like yours, sobering perhaps a little bit, because of course what we hear all the time is, well, you know, you guys can be radical as you like, but then in the end the courts will decide. I don't think we have time to have follow-up questions because we are running late, but I wanted to ask the audience to thank you with a big round of applause. I think what I personally take is some hopeful statements in what you said. I don't think you've come out here to just kind of spread water onto the enthusiasm. There is a sense that you are engaging with some of these issues in a big way, but of course the law is the law. Now I have views on that, but I'm not a lawyer. I'll let you go and I'll ask my next panel to join. Thanks again.